Hello everyone. This video is an update on Letitia Stauch's court case. This is regarding some documents that were just published. Please like, subscribe, share, and comment on this video. Okay, so I'm going to start off with a slight recap of my last video on this subject, and I'm going to put a link to that video in the description below. Anyway, in that video, I discussed the prosecution's subpoenas for any and all information that they said was going to help with the competency hearing, and I had expressed to all of you my concerns regarding those subpoenas because as a mental health provider, I know that receiving such a subpoena is a nightmare, and that quite often they will get quashed, and if you get one, you need to get a hold of your attorney, plus you need to wait for the defense to file objections and hopefully get them quashed because it is a nightmare to testify. The reason why it's a nightmare to testify is that your duty is to your client as long as your client isn't a danger to themselves or anyone else at that time. You have confidentiality concerns, you have ethics concerns, etc. The prosecution issued documents P13, 14, 15, 16, and 17, which were all requests for subpoenas, and they were to go to the Widefield School District, Academy School District, Fort Carson, Horry County Schools, and Fort Carson. These subpoenas were very, very broad and were requesting any and all information and records regarding Letitia. And I think at this point I need to explain again that the issue of competency is separate from impaired mental capacity or sanity at the time of the offense or offenses at the time that those occurred. Those issues would be more brought up in a full comprehensive mental health evaluation, not a competency evaluation. They are different in their scope and what all is involved in them. And I should also let you know that incompetency is not a defense against criminal charges. If a defendant is incompetent to stand trial, that means that they are incapable of understanding the charges against them, and they are incapable of helping their defense. That's why we have these competency evaluations, because if a defendant is incompetent, they need to receive treatment until they become competent, if they can become competent. And with incompetency, a person that's been charged with a violent crime and has been ruled incompetent cannot be released on bail, and they are committed to the state hospital. So there's no worries there. I know some people were afraid that if she was incompetent, she would get out on bond and that she could be on just house arrest or something like that. But that is not the case. That would be the case if she was not facing crimes of violence, but she is obviously facing crimes of violence. Anyway, in the document that has just been released, the judge does seem to scold the prosecution. Because first, the prosecution requested information in their subpoenas that was not needed for a competency evaluation. The info they wanted went above and beyond a competency evaluation. Plus, the prosecution claimed in their subpoena requests that they always request all that extra information for competency evaluations. The judge points out that in all 12 years on the bench, this is the first time that prosecutors have ever submitted requests like these of him. So he asked them to document and give him examples of when they have been granted subpoenas like that. The prosecution did say that they were granted this sort of subpoena for competency evaluations. When they were asked to submit proof of these grantings of similar subpoenas, the prosecution submitted a document to the judge citing cases But in a footnote, they stated that their claims were not accurate and that they were only granted those other subpoenas after a plea of not guilty by reason of insanity was entered. So the judge was a little bit miffed because they did try to mislead a bit about their record of getting these type of subpoenas. And then instead of just saying, yeah, you're right, we didn't get that kind of subpoena granted, they instead stuck it in a little footnote, which, are small writing at the bottom of a page. So in the footnote, they stated to the judge that in those previous subpoenas, they were granted those subpoenas after a plea of not guilty by reason of insanity was entered. In this criminal case, the defense has not claimed insanity. This is just a competency hearing, probably because of the sketchy things that Letitia's done that are definitely not helping the defense, and they want to see whether she's basically just being a butt or if she is not capable of proper thought and not capable of helping with the defense. What the prosecution was granted subpoenas like this for in the past is for aiding in a full comprehensive evaluation, which goes far beyond a competency evaluation, and that is used in determining whether someone is insane or has mental defect of some sort. But even in those cases where they were granted these subpoenas for full comprehensive evaluations, those were not for any and all records. They were for specific records. And then at the end of these documents, the judge did note that he allowed the subpoena for the mental health records from the Criminal Justice Center. And the judge stated that the defense team has claimed that Letitia has never had competency evaluations in the past, and he noted that if she had had previous competency evaluations, those would have been helpful in the current competency evaluation. And he also noted that records regarding prior mental health treatment could be relevant in a competency evaluation, but that the prosecution never specifically asked for those sorts of documents. He did leave the door open for the prosecution to request specific records later if the defense does try to go with an impaired mental condition or not guilty by reason of insanity defense. In a nutshell, all those subpoenas were quashed, which means they are not allowed. The current competency evaluation has been completed. Letitia is currently back in the jail. The jail records are showing a September 8th court date for her, but it's not on the docket at this time, and I can think of several reasons for that. The courts here were closed for several weeks due to health concerns, so I'm sure that there is a backlog of cases, and they're going to need to get things ironed out in order to get things back on the dockets. Anyway, I'm not sure exactly what's happening at the September 8th thing, if it happens on September 8th. Whatever the state hospital determined in that evaluation, Letitia would go back to the jail before the courts ruled on what would happen next. So we still don't know whether she's competent or not. And there are actually 3 outcomes that could have happened from this evaluation. One is that she was ruled competent, in which case court proceedings would begin. If she's incompetent, she'll be sent back to the state hospital. And the third option is that if the evaluation ended up being inconclusive, if they need to do more observation of her, etc., she still would be sent back to the state hospital. So that's it for the updates for now. Let me know what you think about these latest actions, and like, subscribe, and share the video. Thank you for watching Another Day in the Car with Jules. See you next time. An update to Letitia Stauch's case. Confidential and for count or backload of case